Good morning. I think we'll probably make a start now. Good morning, a very warm welcome to the first of 5 webinars that make up the Cornerstone 2020 Housing Week. My name is Ranjit Bhose, and I'm joined this morning by Andy Lane, Catherine Rowlands, and Ruchi Parekh, who are going to take you in a socially distanced motorcade through the highlights of 2020 and the delights we can expect from 2021, if the world ever gets that far. Now, although this year's seminars are virtual, that needn't stop us from pretending that we're all together as usual. So, to replicate fully the experience of the Gray's Inn pension room, I'd ask you all to find your most uncomfortable chair, ram it against the wall so there's no space to write, and then go and overbrew some coffee so that it's both bitter and thin at the same time, which is no mean feat. If you can do that, then I think you'll be well set. Now, I can also confirm that we're not expecting a fire alarm today, and I have no idea where your fire exits are. However, if you do hear a long, plaintive whining sound, that's probably Matt Hancock screaming about his career. If you'd like to ask us any questions, then please do by the Q&A button, and we'll try and answer them during the course of the talks or at the end. So, with my pointless introduction over that's told you absolutely nothing about the law, and I'll turn to Catherine, but first Ruchi, to look back at 2020. And on one thing, I think we can all agree, it's been one hell of a year. Ruchi.
Thanks, Ranjit. I'll try and, I don't know, maybe provide a bit more information than Ranjit did. So Catherine and I are going to kick off by looking at the year we've had. And unfortunately, or at least fortunately for me, Andy gave us free rein to choose our topics. So I'm afraid we've just picked the themes that we'd like to talk about rather than providing any, chronological overview. But that being said, it's obviously not possible to cover all the highlights or lowlights from the year we've had. And a lot of the topics that we don't discuss are in fact dealt with in individual seminars later this week. But for today, and as a starting point, it would be impossible to ignore COVID-19 or the impact it's had, particularly on possession claims. Thanks, Catherine, you read my mind. You will all be familiar with the stay on residential possession claims. It was imposed initially for 90 days on the 27th of March, and then it's been extended twice, first for 8 weeks and then for a further 4 weeks, until the 20th of September 2020. So we are now effectively on the other side, but it's fair to say that we are nowhere near business as usual. And although the general stay has been lifted, there are a number of new requirements or modifications to the existing rules that are still relevant to those bringing possession claims. This is all covered, well, most of it is covered in the Temporary Practice Direction 55C, which is to remain in force until the 28th of March next year. And I've highlighted some of the key elements on this slide. So, drawing the strands together from the practice direction, the 3 things you need to really think about are what I've got on this slide. The first is reactivation notices. And in essence, if your state claim was brought before the 3rd of August this year, it will not be listed, heard, or considered until one of the parties serves what's called a reactivation notice. Now, the precise requirements of reactivation notices will depend on what stage your claim had been stayed. So, for example, in all notices except for appeals, you will need to set out what knowledge you have as to the effect of the pandemic on the defendant and their dependents. But as I say, the requirements will vary from case to case. So it's not possible to just give you a beautiful overview of what you need to do in each individual case. The next thing then is what's called a Para 6 notice. And this applies to any claim brought after the 3rd of August, whether new or stayed. And what a Para 6 notice requires is essentially when you get to court, you have to bring 2 copies of a notice confirming 2 things. 1, if relevant, you have to state how you've complied with the pre-action protocol for possession claims by social landlords. So, confirm compliance and also provide details of how you have in fact complied. And then second, you need to state what knowledge you have as to the effects of the pandemic on the defendant and their dependents. So there's 2 schools of thought, I think, on the extent of what what you need to put down for this second thing. And some take the view that, well, you just state whatever you know about the facts. But I think there's at least a school of thought that you need to make, some reasonable inquiries rather than just showing up to court and saying, well, I haven't heard from the defendant, so I assume it's all fine. So yeah, I would urge you to, make reasonable inquiries. And then the third thing that I've got on this slide is the position on listings. So the standard provision in the CPR that requires first hearings to be listed not more than 8 weeks from when the claim has been issued has been disapplied. And that really is for obvious reasons. There is, of course, a huge backlog that the courts will be dealing with, and they're in essence just trying to, preempt how long it's going to take to get things back to normal. I should also just state here that this is obviously a very broad brush approach given the time that we have, and you should definitely look at the practice direction for the precise application of the rules to your case. Then on the continued topic of possessions in a pandemic, on the next slide, I flag that the modifications that came into force earlier to the statutory notice provisions do continue to apply. So again, you will recall that those were dealt with in Schedule 29 of the Coronavirus Act, and they are to remain in place until the end of March 2021. Again, here it's, it really does depend on what your case is about. The MHCLG website, in fact, has quite detailed and useful guidance on the subject. So I would strongly urge you to look at that if you're in doubt, or indeed instruct a member of the Cornerstone team. And then just, obviously, I'll just mention the winter truce. So the, over Christmas period, we're going to have a 4-week ban on enforcement, on evictions. And then finally on possessions, just to state perhaps the obvious, but do be prepared for long delays as the courts try to catch up with the backlog of claims. There are an estimated 55,000 cases that that will have, well, based on last year's statistics for the same time period, there is an estimated backlog of 55,000 claims, but that obviously isn't the real figure because it doesn't take into account the knock-on effect of the pandemic itself. So the real number is likely to be much higher. And so realistically, we're not going to be seeing new claims being listed until next year at some point. And the courts are only going to prioritize the most serious cases requiring urgent attention. So, just be prepared really for more delays, unfortunately. The next topic I am going to look at very briefly then is the functioning of the courts during the COVID-19 crisis. And this is not, so much of, it's not necessarily specific to housing cases, but it is useful to just think about because, despite the backlog of cases, it is fair to say that the courts are up and running, although it is still very much a mix of virtual and in-person hearings, depending on what the issue is and where in the country you are. But I did think it important to flag up in this session that if you are listed for a remote hearing, in particular a remote appeal or a trial, then please do look at the guidance that's been issued by the courts on such hearings. I've had at least 2 instances where the parties have been told off about the pagination of the electric bundle. So I would say it is worth getting it right and avoid annoying your judge before you even get started. I've flagged on the slide the 2 most relevant pieces of guidance that you likely need. Just to state here that the civil justice guidance, technically speaking, it only applies to civil courts, but the tribunals will expect compliance too. And I learned the hard way in my FTT trial last week. And then Catherine, if I could have the next slide, please. Thank you. So finally, from me, I just wanted to touch on some of the updates from the licensing world. We usually have a dedicated session on additional and selective licensing and related topics. We don't this year, but that's not to say that the courts and tribunals haven't been busy. A number of decisions have been handed down, particularly earlier in the year, that will be of interest to those practicing in this area. And again, this is by no means a comprehensive survey, but I just wanted to mention a couple of the big updates. So the first decision there is the Waltham Forest and Marshall one in the upper tribunal. And it is a really useful decision on how appeals against civil penalty notices should be dealt with. So the upper tribunal effectively confirmed that the First Tribunal is not the place to challenge local authority enforcement policies. And more importantly, perhaps, it confirmed that the starting point for the FTT should always be that the local authority decision is given considerable or even special weight. Now, while the appeal is still a rehearing, the FTT can, of course, depart from the decision that the local authority has made, but the upper tribunal has confirmed that it should still apply the local enforcement policy when doing so. The second decision then is the Mohammed and Waltham Forest one. And again, this is quite useful because what it does is that it confirms that the Section 72 offence of failing to license an HMO is a strict liability offence and a continuing one. So in effect, you can prosecute within 6 months of any date on which the offence was committed or continuing to be committed. And you're not kind of stopped on the date on which the offence first crystallised or when you first became aware of it. So that's quite useful confirmation from the High Court. And it also said that actually when you're dealing with the magistrate court's informations, you just need to state the bare elements of the offence, and that would be sufficient to satisfy the statutory requirements. And then on my last slide, I just deal with the defence of reasonable excuse, which is obviously relevant to a lot of offences under the Housing Act 2004. There have been 2 upper tribunal decisions on the defence in 2020. The first one, which is IR Management Services, just confirmed that the burden of proof does in fact rest on the appellant on a balance of probabilities to demonstrate that they have a reasonable excuse. Of course, these things are a matter of, fact and degree, but it is quite helpful then to get the decision in Sutton and Norwich, which effectively found on the facts of that case that the lack of knowledge as to a building being an HMO was not a reasonable excuse for failing to license it, even though the appellants in that case had in fact relied on professional advice to that effect. So that's quite a helpful decision, in my view, on what constitutes reasonable excuse. And so with that sort of whirlwind tour of my 3 topics, I will hand over to Catherine. Thank you.
Before Catherine starts off, I think there's one question that's been raised by a delegate that perhaps we can throw open to all of those who are watching, some 219. And that is from someone who says, I'm starting to see evictions come through. Have any of the panel audience had experience of stays since they started again, please? How did the court organise them? How did the tenant pay for the stay, given that so many courts have closed for business in person? I don't suspect that Catherine, Ruchi or Andy have any answers to that, but certainly someone out there of those 219 of you beautiful people may do. So if you could perhaps answer live, that would be great. Over to Catherine.
As Ruchi said, we are departing from our normal practice in our housing updates from doing a chronology, which we would normally do in a normal year, but I don't know if you're anything like me, time has ceased to have any meaning whatsoever. I don't know whether it's Thursday, January, or next Christmas at the moment, because I've been sitting in this room, which is very nice to be able to sit at home and do our work, but it can get a little bit boring and a little bit disconnected from the real world. So I'm bringing us all back to reality with a reminder of perhaps the most boring slide you're going to get in the whole of the 5 seminars that we're doing in this week, a reminder that we had new pre-action protocols back in January. In January, this was the height of excitement in the housing world as new protocols for housing disrepair and possession claims came into force. No huge differences in the possession claims anyway. It's been absolutely overtaken by events, as Richard just explained to us. In the housing disrepair protocol, the words housing disrepair were replaced throughout with housing conditions, marking the fact that the Fitness for Human Habitation Act has now come into force fully. We are now seeing the first of those cases coming through and hitting the courts. We are seeing people having what you might call speculative claims coming through. I think that now is the time when local authorities should be standing firm, setting down markers and not showing themselves to be pushovers as far as these new speculative claims are concerned. There's no case law that's hit the courts yet to tell you about. So that's a little bit of a step into procedure as a theme. The next theme is homelessness, and we've got a couple of interesting cases over the last 12 months. One is the case of El Ahmed and the London Borough of Tower Hamlets. And this one's interesting because Shelter was intervening in this one. And it's the question of what's a good reason for not appealing in time when you're appealing against a decision under Section 204 of the Housing Act 1996. And you will recall that over the past 20 years or so, there have been quite a few cases about the fact that you have to have a good reason for not appealing in time. What is a good reason has been considered in various cases. In this case, the issue was whether lack of legal representation could be seen as a good reason for not appealing in time. In other areas of the law, it's not been. But what the Court of Appeal said in this was there is quite often a housing advice desert, and that is one thing that can be taken into consideration. All of the circumstances relating to the appellant and why they didn't appeal in time are to be taken into account. Disability, literacy, the availability of legal advice. You don't start with any presumptions. Because the test of good reason is a gateway through which you have to pass before the court can even consider the merits of your appeal, the test must be applied in such a way as to avoid reaching unjust outcomes. The difficulty in obtaining legal advice is a crucial part of that picture. That may be a different picture in, say, Birmingham, where you've got plenty of expert lawyers, as opposed to, say, the Outer Hebrides. I know nothing about the Outer Hebrides. I was just thinking of somewhere where might be a legal advice desert. But it's still a question of fact. It's to be considered in every case on the individual circumstances of the appellant, which may make it difficult to decide whether or not you are in the circumstances of good reason. The next case I want to talk about is my own case. The last time I wore a wig and gown in a real court, McMahon against Watford and Kiefer, two cases that were joined together because they both raised the same issue. And that issue was one that I really thought had been bottomed out by that time, but not so. The question really was whether a decision as to vulnerability to someone who is saying that they are in priority need because of a disability needs to consider expressly whether that person is disabled or not, whether the letter has to write out, you are disabled and you are therefore vulnerable, or you are not disabled, you are not vulnerable. And of course, they are two different tests. Disability and vulnerability are two different issues, although obviously the same underlying facts can lead to decisions on both of them. So both McMahon and Kiefer were homeless and eligible, but they were not in priority need despite having medical conditions, which in Mr. Kiefer's case, he'd got a limp and severe wrist pain. He had also diabetes, although it was well controlled. McMahon had chronic back pain. He also had neck, shoulder and arm pain. And you'll recall that in HOTAC, the Supreme Court had told us to focus very sharply, whatever that really means, on whether the applicant is under a disability or has a relevant protected characteristic, the extent of such disability, the likely effect of the disability, and again, all other relevant facts on the applicant if made homeless, and whether the applicant is, as a result, vulnerable. And you see there a sort of continuity between the last slide that we looked at and this slide. You're looking at all the relevant facts. And the question is relevant to what? Relevant to whether they're vulnerable so that harm will result if they're homeless, not relevant to whether they're disabled. There is no need to make an express finding as to whether the appellant is disabled or not. And the important factor is that you mustn't confuse the two. This is what a lot of people think. I am disabled, therefore I am vulnerable. That's not the case. You can be disabled but not vulnerable. You can be not disabled and yet vulnerable, because the definition of disability can sometimes be slightly artificial. For example, when you're considering whether someone is disabled or not, you leave out of consideration any medication that they're on. But when you consider whether they're vulnerable or not, you take into consideration medication that they're on. And in my case of Kiefer, the judge had got so confused by the submissions that were made that he said that my housing officer had erred in considering whether Mr. Kiefer was vulnerable because she'd taken into consideration the medication that he was on, whereas we know from HOTAC that that's absolutely the right thing to do. And the message that I would take away from McMahon and Kiefer is that it's all about a practical assessment of how the appellant lives with whatever condition they've got and understanding how that affects their ability to cope in a homeless situation. It's not a question of looking at someone in the abstract. It's a question of looking at someone in relation to their situation and how they cope with the effects of homelessness in conjunction with the effects of disability. The public sector equality duty doesn't change the statute. Housing Act 1996 tells you to take into consideration disability. It takes it into consideration in a way that complies with the PSED. On the previous case of Geister, if that's how you pronounce it, forgive me if I got that wrong, there was mention of this issue of functionality. That's something that everybody got a bit confused about, don't really know what functionality means. I think following McMahon and Kiefer, just forget about functionality, but there must be a causative link. It's the causation factor that most people forget about. I am disabled, therefore I'm vulnerable. You have to add in the bit, I'm disabled, therefore I can't do this, therefore I'm going to suffer harm in this way, therefore I'm vulnerable. And you have to show the chain of working in order to say that you are vulnerable as a result of your disability. The public sector equality duty is something that really illuminates the way that you do your housing duties. And so it's the investigative and reporting stages of the review that are really affected by the PSED. So you can't wait for the appellant to say, or the applicant at an earlier stage to say, I'm disabled, I've got depression, therefore this, that and the other happens to me. You've got to be a bit proactive and ask the right questions. And it's all about making a thorough assessment of the disabled person and how their conditions are. So asking the right questions, getting the right answers. It's a different test to the one in Dodana, which was a possession case. It's all about what function the local authority is performing and questioning what is relevant to those functions. So there was one thing that was raised in McMahon that we're still waiting for an answer on. The question that didn't get answered in McMahon was whether Section 31(2)(a) of the Senior Courts Act 1981 applies in appeals under Section 204. Because we know from years ago, Begum and Tower Hamlets, that what the county court is effectively doing in a Section 204 appeal is judicial review. Judicial review moved into the county court to make way in the admin court for what are we dealing with? Politically activated appeals and repeated unmeritorious applications by people doing immigration cases and planning appeals to clutter up the courts. Anyway, that's what we made room for apparently when we moved 204 into the county courts. So it's judicial review, but it's not actually judicial review in the admin court sense. So Section 31(2)(a) says the courts in the admin court must refuse relief if it's very highly likely that the same decision will happen if the error that the local authority had made had not occurred. So had it been the case that the county court should have made a finding as to whether A was, or sorry, the local authority should have made a finding as to whether A was disabled or not, would have come to the same decision should the county court refuse relief under Section 31(2)(a). The Court of Appeal in this case, it didn't arise, so they refused to actually give us an answer to that. There for another day, we want to find out from the higher court whether that is going to be the case or not. we await the right case to get that decision. So the other huge issue in homelessness was, of course, coronavirus and the effect of the pandemic on rough sleepers. At the beginning of lockdown, you will recall local authorities were asked by the government to accommodate all rough sleepers. We didn't want people on the streets, as that was perceived to be a high risk factor spreading the virus. And the government actually put its hand in its pocket to the extent of providing £3.2 million at that stage. By 2nd of May 2020, the Rough Sleeping COVID-19 Response Task Force was being created. 5,400 rough sleepers were apparently being accommodated at the peak of the pandemic. It's always difficult getting figures for rough sleepers because, you know, a lot of them are hiding out of the way of people when the counting's going on. But it's about 90% of those known to local housing authorities at the start of the outbreak. Basically, people were brought in to hostels, hotels, other accommodation in a way that has made me absolutely proud of the reaction of the local authorities. You have done such an amazing job in response to this and have helped so many people. And of course, what the point is now is to help people going forward on that. And because people are in places where they're known to the local authority, can reach support, where they've got an address, simple as that, it is so much easier to provide them with benefit support, mental health support, and just somewhere to move on to from that. And so another 160 million brought forward from funding that was already going to be there to provide another 3,300 homes within the next 12 months. It's now moved on to the Next Steps programme. Government figures now saying 14,600 people were brought off the streets by July. Next Steps is to keep people off the streets. And so there's £91.5 million being spread between 274 local councils who've made bids, which have been granted to cover property costs and support new tenancies. Now, £91 million sounds a lot in the abstract, but when you sort of divvy it up between those local councils, it's something about, 100,000, 200,000 for each local authority. It's not a lot of money, but hopefully it is enough to provide some more support. My own local authority, for example, Mill Valley, got 144,000, and they're supporting 44 rough sleepers. So it's quite a small local authority here. We don't have a huge problem with rough sleeping, but hopefully that's 44 fewer people who will be sleeping rough in future and who will be helped to move on to stable accommodation. Big question over the next few months is going to be, what's the status of those that were brought in? Under what powers were they accommodated? Because basically a lot of people just went and said, here's the keys. And were they given licenses? Were they given tenancies? Were they accommodated under Housing Act provisions? Were they accommodated under Section 1 of the Localism Act? I know a couple of cases are going to be in the High Court in the next few months sorting that out. Obviously, my view is the traditional lawyer's answer. It depends. It depends on how you knew those people before, how you knew them to get them off the streets, and what dealings you've had them before and what dealings you're having with them now. So there could be some worms to sort out over the next few months. And one fun thing to let you know about is Shelter again. They've had a huge campaign to end the no DSS discrimination against benefit recipients. Obviously, the DSS hasn't existed for the last, 20 years now. But Shelter did some research that says 63% of private landlords say they don't let or prefer not to let to people who are in receipt of housing benefit, which is daft because, if you've got housing benefit coming in, you've got income coming in, what difference does it make? And if you can get the benefits paid direct, you're gold. I mean, I would prefer to let to housing benefit recipients personally if I had any property, but you wouldn't get me being a landlord. Now, Shelter have been supporting people to bring cases against people who have refused to let to them. So there have been 2 cases to date. One was in York, which was conceded. The landlord said, yep, that was unlawful discrimination. One was in Birmingham. It was undefended. Nobody turned up to say anything about it. It was heard by the presiding judge in Birmingham, Her Honour Judge Stacey, so it has some oomph behind it. So although it's not higher court authority in that sense, there are now precedents that you can point to if you want to persuade a landlord, a private landlord, to accept somebody who's on benefits. So local authorities, private rented teams can point to these. So the first claimant, the York one, was a woman. Second one was a disabled man. Disabled people are 45% more likely than the average person to be in receipt of housing benefit. Women are more likely to be in receipt of housing benefit because they've got the caring role predominantly. And so you have got people who are less likely, therefore, to get a landlord to let to them because of their protected characteristics. And in each case, it was found that that was indirect discrimination, unlawful discrimination. And so it's not the case that they were getting an order that the landlord let to them, but they were getting a declaration and compensation. So, a couple of comments there. Housing benefit being paid in arrears, often claimed back due to breaches by the tenant and less than market rent. Nonetheless, this is unlawful discrimination, and those kinds of comments could be seen as being unlawful discrimination. So have a think about that when you are dealing with people, private landlords, and encouraging private landlords to accept people. Right, I'm going to hand now over to Andy to look forward to the next few months, and we will take any further questions at the end of this session. Over to you, Andy.
Thank you very much, Kate, and thank you, Ruchi and Ranjit, for your contributions earlier. I've obviously prepared heavily for this. You can see the new haircut. It's my wife's, of course, number 3. And I've also put a tie on because I think Mr. Skinner's watching, so I've done that. But more seriously, in terms of what I'm going to be covering, I'm going to be covering what's coming up in terms of the case law I'm aware of in the higher courts, what's coming up in terms of legislation, and also some general reforms that we may see in the coming 12 months or so. Clearly some of that is guesswork, but hopefully it will be useful. So to start off with the case law, the first one which Ricardo from these chambers was involved in at first instance before Mrs. Justice Tibbles, and is now joined by Kelvin on the appeal, is a case which clearly is going to have a real impact for those local authorities and indeed even housing associations with fixed term tenancies, which for whatever reason haven't got a forfeiture clause. And the argument in that case was twofold in a sense. One, whether you could interpret the tenancy terms or the relevant tenancy terms as constituting a forfeiture clause, so allowing the landlord to issue claims for rent or ASB or whatever the ground for possession that one wanted to do. And the second question was whether it needed one anyway. And the High Court decided in that case that you do need a forfeiture clause if you're going to rely on the ground to possession matters, whether that's the 85 Act or whether that's the 88 Act. And on the matter of fact, there was no such forfeiture clause in the Croydon tenancy agreement. And I'm aware it's not just Croydon. There are other tenancy agreements that housing associations and indeed local authorities have. And of course, it means that the net effect is that you can't take, for example, possession proceedings for rent arrears. Now, of course, you could issue a money claim for those rent arrears, but if somebody doesn't have the money or if the chances of recovery are poor, then of course that may not be a very good substitute. One, of course, could seek injunction proceedings, and that may be very effective, as we've seen over the last 6 months during the lockdown, for antisocial behaviour. But again, for a lot of the other tenancy terms that would normally be relied upon in any possession claim, it may not be that helpful. So that's a case coming up towards the end of the year, and clearly will have a big impact on people's cases beyond just Croydon. The second matter you see there, which Ranjit and Ruchi are involved in, is an issue which I have to say I've had come up on cases I've had in the past, although not to the degree that it came up in this case. And in this case, I don't fully understand it, but suffice to say that as so often happens in housing law, every now and then people get to raise an issue that keeps running. And it could be, for example, many years ago, it was stamp duty. And whether the tenancy agreement had stamp duty, and people got bored doing that. And so now it went through a phase of water rates. In other words, if within the tenancy payment terms, water rates were part of that, was in fact the landlord entitled to charge for water rates? And more importantly, if they were entitled to do so, and normally they are, of course, because it's a provision of the agreement, were they charging too much for them because there were restrictions in place under those water resale orders you see? And the arguments for the local authority, I have talked to Ruchi about this morning, and so I'm aware that she knows a hell of a lot more about this than I do, is not simply the question of whether the local authority is acting as an agent for the water authority, or indeed is actually directly the seller. It's a bit more nuanced on that, but that is effectively what is going to be argued. And in terms of impact, a bit like the Kalonga case, it's clearly very serious, not just in terms of ongoing cases and the ability to recover the full rental, which would include the water rates. But of course, if the local authority has been overcharging, it can have an impact on other tenants. And the example given in the judgment of Mr. Justice Morgan was the Southwark case, and some of you will recall the Southwark and Jones case, where £28.6 million was repaid because of overpayments, because the water rates element of the rent was too high and above that allowed in the water resale orders. So a very important case, which is happening, I assure you, Ruchi, it's happening the week after next, not next week. So those are two cases that are coming up, both of which involve people in chambers. The next case is something that I'm involved in and was involved in at the County Court at Luton before Tracy Bloom, Her Honour Judge Tracy Bloom. And it's a case which is meant to be really important because it's meant to be deciding if you are able to appeal against both the Section 184 decision in a homelessness case and the Section 202 review decision, if the review decision is, in inverted commas, late. And as an aside to that, what is the effect of the review decision being late? Now, this is a case that was going to be joined with, and apologies for mispronunciation, but Noguem and Milton Keynes Council, where Her Honour Judge Melissa Clark at Oxford had decided that even though the review decision was late, once it was made, it was the good decision and the only decision against which the applicant had a right of appeal. In our case, we had two arguments. One was that, as a matter of fact, there had been an agreement. The other side says, well, there was no agreement for a new date by which a decision had to be made, but certainly there had been an agreement that further representations were going to be accepted from the applicant, which was only referable to an extension of the review period, and Judge Bloom accepted that argument. In the alternative, and in reliance on a number of county court cases, which those of you who read legal action, which I hope most of you do, there's cases like Job and Lambeth, Maloka and Newham, Castro and Lambeth, Karimi and Southwark, and Kamasi and Hillingdon. Not always consistent, of course, only a snapshot in most instances as to what was decided, but has largely, not entirely, but largely proceeded on the assumption that if you appeal against the Section 202 decision, even if late, you have elected to treat it as a valid review decision, and that therefore that is the decision which you are fixed with, and you no longer have the right to appeal against the 184 decision. I say the cases were joined. I believe that Lord Justice McComb is making a decision on the Milton Keynes case, because I think it will probably be adjourned. And hopefully ours will stay there. But in reality, my own view, for what it's worth, is that it's a problem that needn't have arisen if the parties talk to each other. If, you know, in this case, for example, if one needed an extra week, it wouldn't have prejudiced anyone to just simply agree that and make it very clear. but sometimes that isn't possible, and therefore it'll be helpful to have that clarified. So Ricardo and I are in the Court of Appeal next, whatever that is, Tuesday. The Hussein and Waltham Forest case, which I think I'm writing saying James Finley QC was also involved, so apologies to James for missing his name out there, was to do with the Rehabilitation of Offenders Act, and it was a licensing case to do with 36 different properties, HMO licensing and selective licensing, and the local authority had either refused or revoked the various licensing applications of the landlord, and had relied upon 2017 and 2018 convictions. Now, under the Rehabilitation of Offenders Act, the conviction is spent after 12 months. And one needs to look, if one's interested in this, at sections 4 and 7 in particular. And effectively what the upper tribunal decided in this case was that it is possible to still rely on the spent conviction, and that one has to look at section 7.3 of the Rehabilitation of Offenders Act, which talks about if the judicial authority is satisfied in the light of any considerations which appear to it to be relevant, that justice cannot be done in the case except by admitting or requiring evidence relating to those spent convictions. So if it would be a bit academic, or not academic, it would be a bit technical to exclude them when it would have real relevance to the case, then the judicial authority, in this case it will be the first tier tribunal, should be able to make a decision as to whether it's necessary to include that and whether it impacts upon whether somebody should, in this case, get a license for Housing Act 2004 purposes. So that's going to the Court of Appeal on the 11th and 12th, of November of this year. Then we have a case which, well, my name's there, but quite rightly, the E at the end is a small e, because I didn't have a big role in it, to be fair to Matt, which I think it's somebody commented on that probably. Matt basically did the hard work as always, and he took it through the administrative court and he took it through the Court of Appeal. I joined him for the Supreme Court. And it's effectively a case to do with allocation schemes. I've been heavily involved in allocation disputes, particularly the lawfulness of residency requirements, because of course local authorities can restrict access to their schemes since the Localism Act 2011. And in this case, it was really a challenge to Agudas Housing Association, because they restricted their provision of their housing in some instances to the Orthodox Jewish community. And it was said that that was direct discrimination, which could not in any way and possibly be justified. But both the admin court and the Court of Appeal said that it was able to take advantage of the positive action provisions, which one sees at section 158. It's actually a very interesting case for those purposes, because a lot of times when people complain about discrimination in allocation schemes, and for example, I dealt with Kelvin with Hillingdon cases to do with Irish travellers and refugees, one often comes about with the argument, but if I favour those groups, then some other groups are going to be disadvantaged by necessity. And of course, one looks at positive action, which is clearly something that one is able to apply in the right circumstance to overcome or minimise disadvantage. And the Supreme Court will rule on whether the Court of Appeal was right to say that that was sufficient in this case. And indeed, there is a section 193 argument as to whether charities in any event are able to do it, and they don't have to satisfy proportionality. But it will be very interesting for the section 158 positive action point. Just to show this isn't all about cases that we're involved in, there is a TM and Metropolitan Housing Trust case where we don't know if it's going any further, but it's certainly going further in terms of there being a permission hearing. I've put it in there because people still are slightly obsessed by the public sector equality duty. They still quite understandably and rightly are concerned about discrimination. I'm not so sure about the former, but the latter is clearly very important. And in the TM and Metropolitan case, it was a possession claim, antisocial behaviour, serious antisocial behaviour, where effectively a possession order had been made by the recorder, despite concerns about the public sector equality duty being complied. It certainly wasn't complied with at the start of the proceedings. Sorry, it certainly had been complied then, but it hadn't been complied with when there was a capacity report by an expert. But rather unusually, the recorder said that when the Metropolitan Housing Trust officer gave evidence, that's when they complied with it for the second time. So there's a question about that. TM gave no evidence themselves. They were in accommodation which had been provided for people with mental health issues. And there was no dispute as to the fact that the incidents that had arisen, which were the matters of complaint, were due to the person's disability. So there's, generally speaking, a clear Section 19 issue, and the real issue was a question of proportionality. TM accepted that the accommodation wasn't suitable, accepted that they needed to move to more suitable accommodation, and crucially for the purposes of proportionality, had come up with no arguments and no suggestions as to what else the trust were meant to do. So it's all very well saying it's not proportionate, but one is entitled to say, looking at Ackerman, Livingston, etc., well, you tell me what I'm going to do if I don't do this. You know, what's my alternative? Is there an alternative remedy? So ultimately, it was decided in that case there was no breach of the public sector equality duty at the time of judgment, and it would have made no difference anyway. And that's obviously something we've seen with a lot of the PSED cases, like Luton and Dodana, like Forward Housing Trust, and like Power and Decorum. They're all cases which clearly look at the practicalities rather than the technical aspects. In addition to that, you've got the Bancoli, Jones and Watford case, which won a case, a judicial review claim concerning the relationship of COVID-19 to questions of vulnerability in a homelessness case. Indeed, it was one of the queries that very early on in the lockdown, I was often asked about, but of course you have to go through the usual issues of vulnerability to decide what the position is. And of course, there are interesting questions of timelines and at what point decisions are made compared to the timeline of the COVID diagnosis and so on. But that is something that is coming up on the 8th of October, I think, Kate. Yeah, nodding. So that's this week, actually, isn't it? Good Lord, that's Thursday, isn't it? Yeah. So good luck with that. And Coolgit has also told me that she's got a few cases to do with or rather she's aware of a few cases to do with antisocial behaviour in communal grounds on housing estates because of lockdown and local lockdowns. And more importantly, in terms of what she has got a couple of PSBO and community protection notice appeals coming up with judgments in the new year. So look out for those. And of course, she was very heavily involved in the PSBO, as was Ranjit Tara, that was given in respect of the abortion clinic earlier this year. And lastly, I have a committal application, which you may say is nothing particularly wow, but the unusual feature of it is that we filed a defence to a claim against us. We're a housing association for discrimination, and that defence has led the claimant to issue a committal claim on the basis that it's a document with a statement of truth and there's a false statement in it, and therefore has sought permission from the High Court for committal of the defendants. Needs permission for it first, and what you will be aware of is that from the 1st of October, there is a nice new spanking committal procedure, which you can see there. There's a very good article written by somebody elsewhere, which I've also put on my Twitter account, if you can get through the football. So that's coming up. And then if we have a look at some legislation coming up, something we've also dealt with previously in earlier webinars is the domestic abuse bill from the context of its homelessness impact. The bill itself started in 2019 and likely to pass next year, will provide a statutory definition of domestic abuse. It will strengthen local authorities' duties in respect of the provision of refuges and safe accommodation for those fleeing domestic abuse. It will prevent cross-examination of victims by the perpetrator in civil and the family courts. And in homelessness context, of course, it will remove the need to additionally prove the question of vulnerability. In other words, if somebody is accepted as having suffered domestic abuse, they will be treated as in priority need, which is obviously a very positive step, and I think welcomed by most people. There is clearly a question of to what extent can the local authority make inquiries, and the burden of inquiry is very much on the local authority and not the applicant. And to what extent must they simply accept what is being told them? So clearly there are still kind of issues to be ironed out, but that's an important change that will go through and is supported by the government, so will go through. And just very briefly, there's also information and provision in that legislation for those with lifetime tenancies, those with fixed term tenancies being provided with lifetime tenancies if they're fleeing domestic violence rather than another fixed term. There were similar provisions in the Secure Tenancies Victims of Domestic Abuse Act 2018, which haven't actually been brought into force yet, in relation to people leaving accommodation which was long-term anyway. But that hasn't been brought in, but they've made it anyone leaving such accommodation will be provided with the same or different accommodation if they are fleeing domestic abuse. In terms of the Rented Homes Bill, I'm not going to go into that. You can see the bits there. It's unlikely to pass because there is the government's own bill, which at the moment they're sitting on, which I'll briefly mention in a second. So if you can go on to the next page, we get the second legislation, and this is clearly massively important information arising, of course, from the dreadful Grenfell fire in June 2017. Various things happening. Of course, the inquiry is still going on. Brilliant reporting by Inside Housing, and in particular Pete Apps, which you can follow as to what's happening there. Fire safety bill, fire legislation is pretty much unchanged since 2005. This is clearly a commitment to bring forward the bill, and its purpose is to clarify, I'm reading now, the Regulatory Reform Fire Safety Order 2005. And to clarify that it applies to external walls, including cladding, balconies and windows, and you can immediately see the importance, and individual flat entrance doors in multi-occupied residential buildings. And there's other provisions in terms of fire and rescue authorities having certain enforcement powers, etc. It's also the piece of legislation where they will seek to enforce and bring into force the provisions arising from the inquiry which the government accept by way of statutory instrument. The second bill on that page, the Building Safety Bill, is similarly a crucial bit of legislation, similarly related to what happened at Grenfell. 334 pages. I haven't read it all through, but it's massively important, and it's designed to introduce greater clarity on accountability, and particularly for those who are managing safety risks in high-rise buildings. There's going to be a building safety regulator housed in the HSE, and there's going to be a stricter, more stringent regulatory regime at the design, construction and the occupation stages. And obviously details to follow, and it's only come out in draft form a couple of months ago. Going on to the next slide. I've put this in because I mentioned earlier about the private members bill coming into the House of Lords, abolishing assured short hold tenancies. This is what was meant to be happening, and I say was meant to be. This is Chris Pincher, MP, and a quote from him. He's the Minister of State for Housing. There's an element in which we're all Ministers of State for Housing. There's been quite a lot of them. I think this is the 10th one since 2010. So it's about one a year, and he's been in since February, so I'll give him a couple of months. And obviously he was asked, particularly given the lifting of the stay on the 20th of September, well, what are you going to do about the commitment to stop Section 21? And he says, well, it's still there, but not yet, I think is fair to say. I think the commentary at the moment is it's been slightly kicked into the long grass. There may be an excuse in terms of obviously Brexit and coronavirus being clearly the thing that's taking up parliamentary time, although the cynics amongst us may argue that coronavirus isn't taking up much parliamentary time at all, which is part of the issue. But it's still part of the government's plan, the Renters Reform Bill, so it's a wait and see issue, really. The next slide, I'm a bit over my time, so I'm just very quickly going to say, I only put this in there because the reality is that fixed term tenancies, or indeed flexible tenancies, since the Localism Act 2011 brought them into force in the 1st of April 2012, have got a bad press, and quite understandably so. And a lot of people have said, we're not doing them anymore. Now, of course, the reasons why they came in were perfectly laudable. Social housing should be for people in housing need. And therefore, at the end of your period, whatever that's 5 or 6 years, maybe the local authority or the housing association could have a think about whether you still need social housing. Well, certainly my experience, and yours may be different, but my experience is there's been very few decisions that somebody can't stay in the property, unless they are somebody who is already in breach of the tenancy, for example. But in terms of whether they need social housing, there's very few decisions of that type. And of course, it's also very unsettling in terms of things such as schooling and so on for people with children and so on. So a lot of landlords are no longer doing that. And of course, it also causes problems if you don't have a forfeiture clause, as Ricardo will tell you. So it is a problem. And I think some landlords are backtracking on that. And the last bullet point on that page will simply tell you about the government's real interest, which is owning your own property and making it even easier to be a shared owner. And of course, all I would say about that is it's great if people can own their own homes, but one has to be cautious, of course, because shared ownership, you're an assured short-hold tenant until you've staircased up to 100%. And there are repair issues as well, which, to be fair, they're seeking to deal with in the new model announced a couple of months ago. But of course, people often don't go into it with their eyes open and understanding precise details. So it's very good for some people, but one has to be careful that it's still an assured short-hold tenant until you've staircased to 100%. And the next slide, housing courts. Well, there is a very good webinar which I'm booked on, which I think is the 23rd of October, which I know that Mr. Skinner is going to be talking at, so I would recommend that. I personally think it's a dreadful idea unless they give me a job in it. I don't see why it's needed. What we need better resources. District judges are perfectly capable of dealing with housing. Even circuit judges can have a crack at it. So I really don't think there is a problem there. Clearly there needs to be changes, but a lot of that is resource driven, and a lot of the problems is resource driven. I'm not convinced that the housing court will make it different, and there are real problems and concerns as to will it mean that you don't get people who are properly legally aided and supported. And although I deal primarily with landlords, it's still very important for most of my clients that people are properly advised and fairly advised. And so I personally am against it. There was a justice report earlier this year, on the 5th of March, that came out, which the eminent Silk Andrew Arden chaired, and he was very much in favour of a housing dispute service. And I think I'll leave it there in terms of what I think of that. So I don't think anything's going to happen quickly, and certainly not in the next 12 months. And lastly, and it will be last, is the question of planning. And it'll be last because I know very little about planning, which is why I'm not on the planning team, and they're doing incredibly well in the recent Legal 500. Planning-wise, there is a white paper. All I would say about planning at the moment is they're looking at altering the formula for calculating housing need. Controversial, as that will increase house building in many conservative areas, and that hasn't been seen as very positive things for those local MPs. They're looking at fast-tracking consultation. They're looking at a new zonal approach, and they're looking to encourage the government's commitment to build 300,000 homes per annum. All I would say about that is two things. Firstly, consult our planning team. There's some excellent people you'll see on the website. And secondly, 300,000 properties a year, absolutely. But I think, as everyone says, they've got to be the right properties in the right areas, and they've got to be affordable. And just to finish off by this reference, of course, affordable doesn't necessarily mean affordable rent. The technical term, social rent in many areas is what is affordable for tenants. So apologies for overrunning, but that is my section. So thank you very much for listening.
Thank you very much, Andy. I think just that brings to an end this morning's webinar. There's one question asked off topic. Let's see who can answer it. I have a disrepair case where the tenant's using a storage room as a bedroom. Can we insist the tenant stops using the storage room as a bedroom? The room is damp and has a bed fitted in it, which the tenant says is hard to remove to do damp works. Any ideas? I reckon you can't, personally.
It's a storeroom within the tenant's property.
Yeah, I mean, if it's just part of the tenancy and there's nothing in the provisions that says which rooms can be used for which they won't.
No.
Could be an overcrowding issue. Maybe it was let to this family on the basis that they had X number of residents within the permitted use. So there could be that issue. But other than that, you can't tell them not to sleep in any particular room of the property. But you can also require them to give access for the disrepair issues. That's another section. That's a different question, whether you can make them take the bed out to allow damp works as opposed to not using it at all.
Yeah, well, obviously, I mean, if the bed has to be removed so the landlord can undertake works for which they are liable, then it must be removed. That's an implied obligation.
Yes, of course, anyway. If it's tenant damage, then it's the tenant that's responsible.
There we are. That's our answer to your off-topic question and some off-topic answers. Tomorrow's webinar at 3 o'clock concerns the perennial problems of dealing with defendants with mental health issues and capacity points in ASB cases. I recall that was a problem back in 1989 when I started practicing, carrying to court laminated copies of Wookie and Wookie Re-Essa Minor. I don't think it's got much better in the last 31 years. If you'd like to tune into that webinar or any of the other ones during the course of this week, please go to our website and sign up. I assure you they'll all be great, or at least they will be once they're written. It is football transfer deadline day, and we'd like to bring you up-to-date news. So just if you're interested, Arsenal have released Gunnosaurus, the club's mascot of 25 years, apparently a COVID-19 cost-cutting measure. A sad day for footballing dinosaurs everywhere. Finally, thank you very much for attending. Thank you for continuing to support Cornerstone. We really do appreciate it. And we really hope that we'll be able to see as many of you as possible personally in 2021, when even the bad chairs and the even worse coffee will be worth it. Thanks very much indeed. Bye-bye.
Can I just say the slides will be available on our website very shortly.
No, you may not. Thank you. Goodbye.
Bye-bye.
Thanks.
Bye-bye.